All right, good morning, everyone. I'm Judge Jackie Powell. This is First Appearance Court, and today I'll let you know if I've determined probable cause, and then we will also talk about release conditions. Today, I encourage you to speak with your attorney before speaking on the record, because everything in this courtroom is being recorded and can be used against you at a later time. If you are represented by the attorneys from the Public Defender's Office, you need to know that in the courtroom with me, I have Attorney Dale Miller, and also over at the main jail, Mr. Hector Romero. These attorneys are also available to you, those of you who are at the other facilities. Also in the courtroom with me is the attorney from the State Attorney's Office, Mr. Eric Linder, as well as we have representatives from confinement status, pretrial supervision, and the clerk of courts. And these persons are here to facilitate the morning's process. They can add additional information if needed. If you are represented by private counsel, they will come to the courtroom, and if your attorney is not here, you can let me know, and we will see how we can facilitate you through that process. Please note that just because a private attorney is representing you on a pending matter, or maybe have represented you in the past, does not automatically mean that they're representing you here on this new arrest. So please make sure that you or your family have contacted private counsel before telling me that you are represented by that counsel. I oftentimes try to make phone calls only to be told that they're not representing you on this particular case. All right? After today, your case will be assigned to a specific division judge, and then moving forward, any pretrial motions, or if subsequently you end up going to trial, will be heard before that division judge. For some of you, if it's a municipal ordinance violation or a misdemeanor case, depending on what's going on with you today, you may be able to resolve that case at first appearance. But if you are charged with a felony, or you're facing a felony charge, or there is a violation of probation with already a no bond hold, that cannot be changed at first appearance. So that's just for your information this morning. All right? There are two persons that I've been told that the jail has asked to call out of turn. So can we address Calvin Dosilma?
Page 31, Judge.
Thank you.
He's here, present, Judge May.
All right, Mr. Dosilma is before the court. Charge 1 is burglary, unoccupied dwelling unarmed. Number 2 is 2 and 3 are number 2 is grand theft. Number 3 is grand theft auto. Number 4, resisting officer without violence. Number 5, fleeing and eluding law enforcement at high speed. 6, 7, and 8, 9 are violation of pretrial felony, and those are on no bond hold warrants and are not for magistrate. Number 10, burglary, unoccupied dwelling unarmed. Number 11, grand theft. Number 12, burglary, unoccupied dwelling unarmed. 13, grand theft. 14, burglary, unoccupied dwelling unarmed. 15, grand theft. 16, petty theft. 17, grand theft. 18, burglary. 19, grand theft. 20, larceny of credit cards. So, sir, I find probable cause for all these charges, and I'll hear from the attorneys at this time.
Your Honor, the state's going to be requesting bonds in the following amounts: $20,000 on count 1, $5,000 on count 5, $15,000 on count 10, $15,000 on count 12, $15,000 on count 14, $5,000 on count 18. Your Honor, the state not only has a concern for property of the community, but also Mr. Dosilma's future appearance in court. These are all concerning allegations, but they were also allegedly committed while he was supposed to be on a GPS monitor. He's already been found to have violated his GPS monitor by removing it, as noted in the pretrial warrant violation warrant that Judge Coleman had signed, ordering that he be taken into custody. The state would also be requesting that a GPS monitor be placed on him on these new offenses.
Okay.
Judge, I did advise Mr. Del Selma that on counts 6 through 9, basically there's really nothing, it's not for magistrate, it's gonna have to see his division judge for some sort of relief. And speaking of Mr. Del Selma, he's 17 years old, he is not working, he's financially indigent. He goes to school, he's an 11th grade judge, so he is financially indigent, there's really nothing he can afford. So we're asking you to take that into consideration, determining reasonable release conditions for Mr. Del Selma.
All right, I have 3 probable cause affidavits that allege burglaries October 6th, October 8th, and October 9th, October 7th. All the way back to September 20, in September. There's another September 21st. There's several burglaries allegations here. And so based on that this morning, and taking into consideration that Mr. Dol Silma was on pretrial supervision, I am going to impose at this time $20,000 bond on 1, 2, 3, and 4. Standard bonds will remain in place. Number 5, $5,000 bond. 6 through 9 are already no bond holds from his division judge. Number 10, I'm going to impose a $10,000 bond. 11 has $1,000. Number 12, 10,000. Number 13, it has 1,000. Number 14, 10,000. The other standard bonds in place. And number 18, $10,000. And if Mr. Dol Silva posts his bond, it will be back on a level 2 pretrial supervision. No victim contacts and no return to any of these locations. Okay. All right, the next person is Ellis Louis Jean.
That's page 16, Your Honor.
Thank you.
He's approaching, Judge.
All right, Mr. Louis Jean is is before the court on 2 charges of home invasion with a firearm or other deadly weapon, and I find probable cause.
The state would be seeking a no bond hold on each count, relying upon the arrest warrant affidavit prepared by Detective Jonathan Zeller, seeking finding proof evidence presumption grade for first appearance purposes only.
All right.
Requesting that you can contact Judge.
All right, based on these allegations, this morning, I am going to make a preliminary finding of proof evident presumption grade. Mr. Louis Jean will be held no bond until further order of the court. This is without prejudice for him to have a bond hearing before his division judge. No victim contact, which means no phone calls, no text messages, no social media, no third-party contact. Do you understand that, sir? And there are two alleged victims in this case. Okay?
And Judge,
Yes.
just for the record, if I may just
Yes,
object for the record.
okay.
At the court finding proof evident presumption grade based on a affidavit to arrest.
All right, so noted. All right. Mr. Romero,
Yes, Judge, I'm sorry.
up to what, no, that's okay. Up to what page do you have persons in the room?
I believe I'm up to page 17. No, I apologize. 19, Judge, 19.
All right, so can I give you some names that are
Yes,
beyond
Judge.
that.
Yes.
On page 20, Ladario Simon. On page 21, Estinfil Phils Magri.
Yes.
And on page 22, Tavares Givens.
Yes, Judge, thank you.
All right,
We'll
thank
get
you.
that.
Okay. Rochelle Charleswell. Folks, when those
No
persons
problem.
are in the room, I'll be able to address them. They're not in the room yet, for those of you who signed in. Okay?
Medical reset.
All right, Ms. Charleswell is a medical reset, thank you. And then Tiffany Garcia Velez.
Judge, I've been informed she bonded.
All right, thank you. Barbara Valdez,
Paul Ryan.
thank you.
You can call, Your Honor.
All right, Ms. Valdez is in court. You have to reset. Jasmine Anderson.
Call on, Your Honor.
All right, Ms. Anderson, you are before the court today. The charges, these are add charges. Number 4 is now murder, dangerous, depraved without premeditation. And number 5 is committing a first-degree felony with a weapon. And I find probable cause for these charges, okay? Should this be a change of charge?
No,
This is
Your
an
Honor,
ad
it's,
charge, Your Honor. She's currently being held without bond on count 1 in this case.
Right.
And I did speak to her earlier. We're not going to challenge any findings this morning, and we're going to reserve that for an argument before her division judge.
Okay,
and Your Honor, just to answer your question, it wouldn't, we haven't made a final decision yet, obviously. and
okay,
So it's just an ad charge, but considering that you found proof evident or presumption great for attempt, and the only new information is the fact that the alleged victim passed, I would ask the court to make a new finding of proof evident or presumption great based on the new information.
so,
Again, we would register an objection to the court finding proof evident presumption great based solely on an affidavit to arrest.
all right, so at this time, I am making a preliminary finding of proof evident presumption great. This is without prejudice for Ms. Anderson to have a bond hearing based on State v. Author before her division judge. And at this time, and also taking into consideration that this court previously found proof evident presumption great when the charge was attempted murder, Ms. Anderson will continue to be held no bond. And
I'm not seeking any bond on count 5, Your Honor.
so we'll ROR on
That's
count
fine.
5? All right. ROR on count 5, okay? And we continue to say, I believe there was no contact with the victim's family, and that remains in place. Okay, all right, Kayla Kistler. So, I didn't see her sitting there. Oh, all right. Ms. Kistler, you're before the court on one charge of failing to re-deliver hired vehicle, and I find probable cause. Does Ms. Kistler have any priors?
We're checking that right now.
Okay.
No priors, Judge.
Your Honor, I spoke with Ms. Kistler this morning. She's a 7-year resident of South Florida. When she was arrested, at the place where she was arrested, apparently she has a service dog who was with her at that time. She doesn't know what happened to the dog or what's going to happen to the dog. We're asking the court to consider, based on her lack of contact with law enforcement, that she be released on her own recognizance on this charge.
Ms. Kistler, I am granting the ROR at this time. You need to make sure that you stay in touch with your attorney so that you know when you have to come back to court, okay?
Thank you.
All right, Brianna Webb. All right, good morning, Ms. Webb.
Good morning, Judge.
You are before the court this morning. Charge one is passing forged or altered bill or promissory note. Number two is a traffic KPS, and number three is a violation of felony probation, which has a no bond hold. This is for Lee County. There's a hold out of Lee County. So I find probable cause this morning, and I will leave the standard bonds in place at this time. Charge one has $1,000, and number two has $500.
Thank you, Judge.
Okay? Rebecca Strobridge.
Look, Broward, Judge.
No problem.
All right, Ms. Stro, good morning. Ms. Strobridge is before the court on one charge of unlawful possession of personal ID of another, 5 or more, and I find probable cause.
Ms. Powell, if I may, I do work at All Things Can Do, Incorporated. I have a job. Is it possible, that I can be either ROR or pretrial, ma'am? I do have to go to work. I have 4 children, that my mom is disabled and she's an amputee and she has them right now. I can't get in contact with them. I asked the lawyer to try to call my dad or my boss. But if you can help me with this, I will go to court. Somebody gave me a purse.
All right, ma'am.
That's enough, ma'am.
I'm going to tell you to stop talking
Okay,
for,
sorry.
because everything, well, I'm just gonna tell you that everything in this courtroom is being recorded and can be used
Okay.
against you at a later time.
Yes, ma'am. I apologize.
Was Ms. Strobridge before this court recently?
A month ago for unlawful use of false name ID.
I remember.
She had-
Judge, just to add to Ms. Strobridge's argument, she has been living in South Florida since 1993. She's been at the same address for 6 years.
Is she out on bond on the other case?
No, she pled that out. She also had another unlawful use of false name ID last year. 2017 burglary of a conveyance, she violated probation. 2017 grand theft auto, she violated probation. 2016 unlawful use of false name ID. 2013 2 counts of theft. Another theft in 2010, another in 2008. Unlawful use of a driver's license 08, theft 07.
I am going to leave Ms. Strobridge bond in place at $1,000. And I guess we don't know. All right, $1,000 is the bond. Sonia Lopez. Ms. Lopez bonded? Thank you. Kiana Pettyway.
With you?
Your Honor?
So Ms. Pettyway, yeah, okay.
Yeah, it was a medical reset the other day when we were last here, but now it's a refusal. I was gonna mention at that time, just reading the PC, I had some mental health concerns.
Yes.
Oh, but you know what? I'm sorry, Your Honor. I
It's
didn't
a-
realize count two's a felony,
a
so we
felony,
couldn't transfer
yeah.
anyways.
All right.
I would ask if the court could make a probable cause determination. Obviously, I have no objection to her being brought back for bond.
Okay.
I know.
Your Honor, I don't see that my office represents Ms. Pettyway in either case.
All right, what I'm going to do is I'll reset one more time, and if she refuses tomorrow, then we'll go from there. Cynthia Espinoza. Cynthia Espinoza.
Present, Judge, I'm in.
All right, Ms. Espinoza, you are before the court on an out-of-state felony hold. This is for Illinois, and it's a no bond hold, so you should be going before the extradition court next week. Okay? Canaris Hall,
He's approaching Judge Sierra Maine.
Mr. Hall, you are before the court this morning for two out-of-state felony holds. Both charges are out of Georgia, and those are no bond holds, and so you should be going before the extradition court next week. Andrew Orton,
Mr. Orton, Judge, is here at Maine, and he declined the services of public defender. I believe he's gonna be hiring his own attorney, Judge.
all right, Mr. Orton, just so we're clear, you understand that you are entitled to an attorney for this hearing,
Yes, ma'am.
and you're refusing the services of the public defender's office this morning?
Yes,
All right? And it is your intent to hire private counsel, correct?
correct.
All right, so
Yes.
you are before the court this morning for one charge of touch or strike battery, it's domestic violence. Number two is tampering, and I find probable cause.
Your Honor, I see no history. The state would be requesting a $1,500 bond on one, $1,000 bond on two in order to no victim contact.
All right, so Mr. Orton, you have a $1,500 bond on charge number one and a $1,000 bond on number two. And I'm ordering no victim contact. And sir, what that means is no phone calls, no text messages, no social media, no third-party contact. Do you understand that, sir?
Yes, ma'am.
All right. All right. Bruce Alvarez.
Alvarez, Judge, is approaching. Judge, my understanding is he has private counsel, Mr. Felipe Viscarando. And Judge, I don't know if my colleague had an opportunity to call him.
All right. Mr. Miller, did you have an opportunity to call Mr. Viscarando, that they said? Do you have a phone number for Mr. Viscarando, sir?
I don't know it by heart, but I know he's right across from the building of Broward, right across from the Broward Courthouse.
What is the first name?
Felipe, Felipe, Vizcarrando, Vizcarrando. Felipe Vizcarrando. He should know about my case already.
Why, did you or your family get in touch with him?
Yes. He has all the evidence regarding the case and everything.
All right, can somebody see if they can locate Mr. Viscarando on the Florida bar?
He has everything.
Judge, I have a phone number here, 954-463-1257.
Okay,
That should be it.
And that's the number that's on the Florida Bar
That's the
website.
office.
good morning, this is Judge Powell, I'm calling from First Appearance Court. Is Mr. Viscaranda in the office?
Regarding which client?
Oh, is he in the office?
Regarding which client?
This is Judge Powell, is Mr. Viscaranda in the office?
No, he's not.
All right, ma'am. There is a gentleman before me this morning, and I need to let you know that you are on speakerphone and we are in open court. Bruce Alvarez is before me this morning, and he tells me that he's represented by Mr. Viscaranda.
Okay. Okay, so you want Mr. Vizcarrando to be there?
Well, I'm calling you to let you know that his client is before me, and you need to tell me what he wants to do. I'm doing this
Okay,
as
so
a courtesy calling him.
Okay, so let me call him. Give me one moment, Judge.
Okay.
So she's cleaning this shift, that'd be more pros.
So no one called my private attorney.
This kid, this guy's got issue, Kiefer. Read this here. Yeah, that's why they dropped it. Bumped it to more pros.
Judge?
Yes, ma'am.
Okay, I just got in touch with the attorney.
Yes.
I mean, we had spoke with the client, the parents, but they haven't retained us. But if he wants, if you want you to come in, Mr. Viscarano, to be
Ma'am,
your courtroom.
I can't tell Mr. Viscarando what to do. The person told me that he's represented by you, so as a courtesy, I was calling your office. If he if he has not retained you, then he's hearing that, so we can move forward. But I'm not telling Mr. Viscarando what to do.
Okay.
Okay?
So he's, okay,
So if he's not gonna come, it's fine. I just wanted to make sure that he's not already retained and to let
Yeah.
him know his client was here if he was retained.
okay,
Okay?
okay.
All right, thank you.
You're welcome.
All right. All right, sir, so you've heard your family is not formally retained, Mr. Viscarando, so.
We spoke with them
Sir,
last night.
sir, I am not going to debate this anymore. You heard the phone call. Your family
Yes,
has not paid him or signed a contract, so he's not representing you. So what do you want to do at this time?
I'm not sure. I have no.
All right, sir, here's the thing. Here's the thing. You have the attorneys from the public defender's office, or you can proceed on your own. Those are your options at this time.
Defender, I don't know, because I have a child.
All right, then we'll recall your case, sir. All right, David Meadows, we'll recall Mr. Alvarez. David Meadows.
Mr. Meadows, judge is approaching. He advises that he has or will be hiring Mr. David Frankel. I believe my colleague, Mr. Miller contacted him.
Okay. Mr. Miller, did you get word from Mr. Frankel? Dave? Mr. Miller? Dale? I don't know. Did you have a conversation with Mr. Frankel on this gentleman?
Yes, I spoke to his assistant, Your Honor. He's in the building and he's headed over this way.
He's coming to court?
Yes, ma'am.
All right, Mr. Meadows, I'll reset your case when your attorney gets here. Recall your case. And Mr. Nanda is not with us still. Angel Bilch?
Mr. Bilch is indicating that he has an attorney Michael Sykes. I spoke to a Mr. Sykes who does tax law in Washington DC. He says he doesn't represent him. Mr. Bilch has another case pending. He is represented by the conflict counsel's office. So I'm not sure how to proceed, but except to tell the court.
I had an opportunity to speak with Mr. Bilch. He did advise me as count one. It's a more serious case, so at this time, he has a $500 bond on this case. He's not asking for anything to be done on this case.
All right, so you have a misdemeanor KPS, and it does have a $500 bond, as was indicated. It looks like he didn't show up for arraignment on October 2nd, okay? All right, Duriel Akins. Yes.
Your Honor, Akins, I spoke to Akins this morning. He indicated that he wants to plead this case out.
Yeah, well, all right, two people speaking. All right, he wants to plead the case out. Yes, confinement? That what? All right, so Mr. Akins is where? All right, thank you. So, Mr. Akins, you're before the court on a misdemeanor KPS. I'm told that it was issued October 2nd, but that you were in custody at the time. So this charge is a trespassing charge, and I don't know, what do you want to do today, sir?
I just I plead guilty to it.
Well, does he have other pending matters?
He's being held on a felony theft, which makes me wonder.
All right, well, I don't know. Is he represented by the Public Defender's Office, Mr. Miller? Well, this is a KPS, so is he represented by the, oh, this is out of the satellite.
He's being represented by the PD on the felony theft.
All right. Well, you've heard his request to resolve the case today. It's a trespassing charge,
He offers withholding court costs from the state.
okay?
I have no standing here, but if I did, I would have no objection to him proceeding this morning.
All right, Mr. Akins, you have a pending matter. I don't know how this, or if this case will have an effect. I don't know when the other case occurred. So I'm letting you know that right now. If you want to resolve the case, the state is offering a withhold adjudication and court costs. Withhold adjudication means no conviction on your record, and the court cost, I believe, is $293 that you would have to pay. So do you want to resolve the case, or we can leave the bond in place since you're,
And then you think I could run it off with my other matter if it take effect?
I don't know anything about your other matter, sir. That's what I'm saying.
Mr. Aiken, she's saying that this case has nothing to do with your other case, and you can plead it if you want, or take it to trial if you don't.
Yeah, I'll pay the guys right. I'll just plead guilty.
Hey, Leon.
All right. So please raise your right hand, sir. Do you swear or affirm to tell the truth?
Yes.
Okay, you can put your hand down. And do you understand everything that we've discussed here today?
Yes.
Is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
No.
Do you need any more time to speak with your attorney?
No.
You understand that you have the right to go to trial, but by taking a plea today, you are giving up that right.
Yes.
Have you ever been treated for mental or emotional illness?
Yeah, mental illness.
Is there anything about that illness today that would prevent you from making a decision about this case?
No.
And do you understand, sir, that if you are not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
Yes.
All right. What plea do you wish to enter at this time? You can enter a guilty plea or a no contest plea.
I'll probably go with the no contest plea.
All right, I accept your no contest plea. I find that it's freely and voluntarily given. and your sentence serves a withhold adjudication and court costs. Good luck.
Okay, thank you.
All right, Radcliffe Barnett.
Conti, Your Honor.
All right,
How you doing, ma'am?
thank you. I'm well, Mr. Barnett. Sir, you are before the court today. There's an ad charge. This is also for petty theft. This is also, he was in custody at the time? All right, so it's on a petty theft charge that, the KPS was issued, but it looks like you were in custody, on October 2nd. I don't know, is there something else holding Mr. Barnett in custody?
Got a strong arm robbery as the top count.
Okay, all right, so sir, you have a $500 bond. I am going to leave that in place, and, yes, all right,
The court's ready. I'm ready to proceed on Mr. Alvarez, and to let the court know, Mr. on page 20, 21, and 22, all three individuals that the court requested are here.
all right. Okay, Mr. Barnett, you have a $500 bond on this ad charge number 4, okay? All right. So you're ready with who now? Mr. Alvarez?
Mr. Alvarez, correct. Mr. Alvarez, come on up, please. Be careful, sir. Be careful.
All right, Mr. Alvarez is before the court. Charge 1 is aggravated assault with a deadly weapon. Number 2 is touch or strike battery. Number 3 is battery on an officer or firefighter. And number 4 is resisting officer with violence. All right, and I find probable cause for these charges.
Under the state's going to be requesting a $10,000 bond on count 1, $1,500 bond on count 2 and 3, $500 bond on count 4, no victim contact. Just noting the strength of the evidence. There's an independent witness that observed Mr. Alvarez pointing the firearm at his stepfather. It was captured on video surveillance. The battery he allegedly committed against his stepfather and the officer is essentially the same. And additional cause for concern, Your Honor, I would note, in 2016, he was arrested for criminal mischief, and that was against his mother. I would note, Mr. Alvarez advised the reason this happened, he ripped the interior rear view mirror from her windshield, shattering the windshield, and did this because his mother took him to McDonald's instead of Burger King. She declined prosecution in that case as well.
Judge, Mr. Alvarez did advise me of that as far as his prior isolated contact with the criminal justice system. He is not a convicted felon. He's a registered voter in our community. He has very strong ties to our community. He's basically been here his whole life. He's a graduate of a local high school, class of 2014. My understanding is on count 1, I believe the alleged victim is his stepfather. My understanding is stepfather is going to come, after he spoke to another attorney yesterday, I believe he's going to come in and do a waiver of prosecution. Having said that, Judge, in reference to the bond request from the state as far as counts 2, 3, and 4, those are reasonable. What we're going to be asking for is on count 1. We're going to be requesting, rather than a $10,000 bond, this gentleman, since he has basically no prior convictions, we're going to be requesting a $2,500 bond on his behalf. Now, he is working. He works for a company called Delivery Boys. He's been working there for about 5 months, making $11 an hour. He is supporting both himself and his fiance. His fiance is pregnant. She's about 3 months pregnant, specifically about 2.5 months pregnant. She's not working. So he's the sole provider of the household. My understanding, the alleged victim and Mr. Alvarez do not live together. They live apart. This is a domestic situation. He will abide by whatever court orders this court places on him. He will be coming back to court, Judge. He's not a flight risk. But, Judge, we're just asking, considering his financial resources, we're requesting a $2,500 bond on count 1, Judge.
Is the girlfriend who's pregnant the same person who's mentioned in this probable cause affidavit? Madeline Franklin? All right, I am going to impose a $10,000 bond on one. The circumstances started with it says his girlfriend that he was slapping around, and she refused to provide a statement to law enforcement, but that's how that started. And so $10,000 on one, 1,500 on two, 1,500 on three, 500 on four, and no victim contact.
Judge, for clarification, is his girlfriend slash fiance, is she one of the listed victims on the probable cause?
No, that's what I'm saying.
No?
She's
Okay.
saying that she doesn't want to, but that's how the incident started, that he was slapping her around. All right. All right, David Meadows.
Mr. Meadows is here.
All right.
And he's the one that had Mr. Frankel.
All right. Mr. Miller, did you call Mr. Frankel?
Judge, I spoke to Mr. Frankel's assistant. She indicated that he's in the courthouse today, and she would ask him to stop by.
Oh, no. Okay, so, no, your attorney's still not here, Mr. Meadows. I'm sorry.
Sounds like.
All right, on page 20,
Yes.
we have Ladarius Simon,
Mr. Simon's here, Judge, at Maine.
okay?
Judge, someone's here on behalf of Mr. Simon.
Okay,
And Judge, my understanding, he's declined to serve as public defender. He's going to be hiring his own private attorney, Judge.
all right. All right, Mr. Simon, you're before the court this morning. Charge one is selling a scheduled drug. Number two is DUI, alcohol or drugs, second offense. Number three is resisting officer without violence. Number four is a traffic infraction not for magistrate. And number five is a violation of felony probation. And that has a no bond hold. You'll see Judge Scher tomorrow at 8:30 a.m. on that charge, okay? I find probable cause, and I will leave these standard bonds in place, and you will see your division judge tomorrow, okay?
And Judge, did you want the person here for him to just,
I don't, well, did you want to say something? No.
Did I?
No, sir, that's okay. Estin Phils Magre,
He's approaching, Judge. You see him, man? Come on, let's sir.
on page 21. All right.
Judge, Mr. Phils McGray's wife is here today?
All right, if anyone wishes to say anything or speak, you can step up to the podium. All right, sir, you are before the court for one charge of attempted felony murder, and I find probable cause.
And, Your Honor, I got one moment. Looking at the warrant, this is actually charged as an attempted second-degree murder.
All right. All right, so it's attempted second-degree murder.
Honor, I've read the probable cause, the affidavit to arrest in this case, and it reads to me more like an aggravated battery. And so I would argue that the court should find probable cause for an aggravated battery rather than attempted felony murder, and set a reasonable bond in this case.
First off, Judge Scheer signed a warrant, essentially finding probable cause for attempted second-degree murder. Secondly, even if that wasn't the case and this was a PC, stabbing someone multiple times, including, one moment, left bicep, left chest, left abdominal area, and right chest. When the knife was also lodged and left in the victim's left abdominal cavity, would certainly rise above mere aggravated battery and can certainly satisfy the elements of attempted murder second degree.
Right. I found probable cause. I still stand by that for attempted second-degree murder.
Your Honor, the state's going to be requesting a $100,000 bond, pretrial release of the GPS monitor, no victim contact, no possession of firearms or weapons. This is based on the level of violence alleged in this case. Also noting that Mr. Phils McGray just got off of probation before Judge Colra April 30th of this year, and that was on a misdemeanor battery that he pled down a felony to misdemeanor battery and resisting without violence. Okay.
All right, Mr. Romero?
Judge, with Mr., how do you pronounce your last name? Estefel. Judge, my understanding, he's not gonna be able to afford $100,000, nor his family. Now, he works when he can. He works with his cousin in landscaping, doing side jobs, but he's looking for something more permanent. He's only 22 years old. My understanding, he's gonna be reaching out to other family members to help post his monetary bond. But from his understanding, they're not gonna be able to come close to affording $100,000. He owns no sort of property. He did advise me he has money in the bank. He has approximately, from what he told me, around $250. So, Judge, I'm asking you to take that into consideration, determining reasonable release conditions for this gentleman.
All right.
May I have one moment, please?
Yes. Again, did any of the persons who signed in, does anyone want to say anything? Okay. Oh, I've asked twice if anybody wants to say anything. Good morning.
This is my husband. Him stabbing a person, even
Okay,
though I
ma'am,
wasn't.
let me tell you again that this is not the trial. This is not the hearing about the incident. The purpose of this hearing today is for me to determine if there's probable cause and to set a bond. If you have any arguments pertaining to the incident itself, that will be for another time with another judge and after you've had a conversation with your attorney, okay? So if you wish to say anything in regards to setting the bond, I will hear that.
All right, never mind.
I would just ask the court to take into consideration, the alleged victim in this case has been arrested before for
Your
aggravated
Honor, I'm
battery.
objecting. This is not relevant.
And he's a person who has a reputation for violence in the community.
Why are we talking about that to set the bond? This is regards to Mr. Phil Smagri.
It acts as a mitigator in this case, because there are circumstances that the court.
That is not before the court today. No. I am gonna set a $50,000 bond and no victim contact. And that means no phone calls, no text messages, no social media, no third-party contact, no family member getting in touch with the alleged victim, none of that. Do you understand that, sir?
Yes, ma'am.
All right. And no weapons or any firearms? Do you understand that, sir?
Yes, ma'am.
Okay. All right. On
Givens.
page
Givens, I believe your name.
22, Tarvaris Givens.
He's here, President Judge.
And Judge, Mr. Givens, on page 22, his mother, grandmother, and sister are all here on his behalf.
All right, Mr. Givens is before the court. Good morning, folks. Mr. Givens is before the court. Charge 1 is selling cocaine. Number 2 is selling heroin. And number 3 is a traffic capias. And that capias was issued March 26th of this year. The charge there is failure to register vehicle. And that judge did impose a $300 bond on that case. All right. I find probable cause for these charges this morning, and I will hear from the attorneys. And then if anybody from the family wants to say something, you'll also be allowed to speak.
Judge, I see the standard bond are set, I believe, $40,000 in reference to counts 1 and 2, $300 on count 3. What I'm asking the court to do is consider a bond reduction for counts 1 and 2. My understanding, Judge, he's a lifelong resident of Broward County. He's 22 years old. He's a graduate of Hallandale High School. Right now, he works off and on in landscaping. He's looking for something more permanent. He lives in West Park with his mother. He appreciates the fact that his mother, his grandmother, and his sister are here for support. Those are the people that he's going to be relying on to help post his monetary bond. I believe he has very limited contact with the criminal justice system, Judge. He's not a flight risk. He will be coming back to court. My understanding is I believe his sister goes to school. He doesn't know exactly what his mom does, and his grandmother's a school teacher. So I don't think their financial resources are going to be able to come up with the standard bond, which is currently set. That's why I'm asking for a bond reduction on counts 1 and 2. I'm asking the court to consider reducing it from $10,000 to $2,500, and from $30,000 to $3,500. Maybe that's something hopefully the family can afford, but we're going to be hearing from them right now to see if they can even afford that, Judge.
Judge, I'm not sure if this is a standard bond for a second-degree felony, but it seems like Mr. Romero's request is reasonable, considering the fact that Mr. Givens has no prior contacts with law enforcement as an adult. He does clearly have strong ties to the community, just demonstrated by the fact that his family is here today. I would ask the court to release him to pretrial, standard level supervision. There's no indication that he's a flight risk. There's no indication that he's a danger to the community. I understand that this is, according to the affidavit for arrest, that this has been an ongoing investigation, but that doesn't make it something that's particularly dangerous to the community beyond what this level of offense is. And so I'd ask the court to consider pretrial release, and if not, $2,500 per count should be.
Selling drugs is not a dangerous to the community?
Not particularly, Judge. People who buy drugs want them.
Well, Your Honor, respectfully, Mr. Miller, I would disagree. I do believe it is a danger to the community. It does appear it is, as Mr. Miller mentioned, part of an ongoing investigation. This is not a lone event, Your Honor. I would also note, as the court can take into consideration the strength of the evidence contained in the affidavit, Your Honor, considering, and I'm going to also, since I'm going to also be asking that the court keep the special conditions of bond that Judge Usan set, I'd ask that you keep the bonds in place and a more thorough hearing could be held in front of the assigned judge, whoever that may be, if the defense seeks modification.
Your Honor, again, we're dealing with a second-degree felony, a first-time offender, strong ties to the community. I would ask the court, again, if you're not considering pretrial release, to reduce the bond and remove the onerous conditions that were placed by the weekend magistrate, or the judge who signed this affidavit.
Does anyone wish to say anything?
I'd like to say that I would like to see his bond reduced where we can try to help him to get out at a cost that we can afford. Yeah, go ahead.
I just want to say if the bond is reduced, we can basically have two parties. Are these for my birthday?
Come on, go.
All right. I am going to reduce the bond on one to $5,000, the bond on two to $5,000, and Mr. Givens is also going to be on a level 2 pretrial supervision, okay? So he has a total of 10,300, and plus he'll be on an ankle monitor, okay?
Yes, ma'am. Thank you.
Yes,
And Judge, can we dispense with the collateral requirement?
yes,
Thank you.
yes. No, I'm removing those conditions, okay? That's based on the amount of drugs that we're talking about and the number of sale at this time, so, okay? All right. Kevin Edwards, good luck, folks.
Thank you.
North Brown.
All right, Mr. Edwards is before the court on 2 charges for capiases. All right, but it's the charges are 2 battery charges, and so he will see his division judge tomorrow on this case, okay? I'll leave the bonds in place. All right, on page 11, I didn't find one of yours, but I'll go through it, Mr. Shade. On page 11, Troy Green.
It's time served offer, Judge.
All right. All right, Mr. Green, you are before the court on a misdemeanor capias, and that is from 2017. So, Mr. Green, your attorney's here, and the charge is an alcoholic beverage violation. Do you want to resolve this case today?
Yes, ma'am.
All right. And I'll sentence you to withhold adjudication and court costs. Do you wish to accept that?
Yes, ma'am.
All right, please raise your right hand. Do you swear or affirm to tell the truth?
Yes, ma'am.
Okay, you can put your hand down. And Mr. Green, do you understand the offer that has been extended to you?
Yes, ma'am.
Is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak with your attorney?
No, ma'am.
You understand that you have the right to go to trial, but by taking a plea today, you are giving up that right.
Yes, ma'am.
Have you ever been treated for mental or emotional illness?
No, ma'am.
And do you understand, sir, that if you are not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
Yes, I understand.
What plea do you wish to enter at this time, sir? Guilty or no contest?
No contest.
I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence, sir, is a withhold adjudication and court costs. Good luck, sir.
Thank you.
All right, Eddie Wright on page 12.
Yes, ma'am.
All right, Mr. Wright, this is also a KPS that was issued July 29th of this year You did not show up for arraignment, and the charge is solicitation and display, and I find probable cause. It's a municipal ordinance violation. So do you wish to resolve the case today?
Time served, Judge.
Yes.
All right, so if you wish to resolve your case, the city is offering time served. Do you wish to accept that?
Yes, ma'am.
All right, sir, please raise your right hand. Do you swear or affirm to tell the truth?
Yes, ma'am.
Okay, you can put your hand down. And Mr. Wright, do you understand everything that we've discussed here today?
Yes.
Is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
Yes. I probably want alcohol, yo.
All right, then under that circumstances, I can't take the plea if you're, so
Oh, no,
you,
no, I'm tripping. I'm sorry.
you're tripping? All right.
Yeah, I'm sorry.
You'll see your attorney tomorrow, and then maybe you'll be in a better state of mind, your judge tomorrow. You'll be in a better state of mind to take the plea tomorrow, okay? So tomorrow you'll be before your division judge.
I'm just a little bit nervous.
No, that's okay.
Judge, can maybe we ask him the question one more time?
What do you think his answer was?
And
Mr.
whether or not he
Wright?
was, Mr. Wright, whether or not he was under the influence of any drugs or alcohol.
No.
All right, Mr. Wright, are you under the influence of any drugs or alcohol?
No, ma'am.
Can I
No,
get the
ma'am.
paperwork back?
Then the tripping answer probably wasn't the best one for that.
I'm sorry, no.
I know. All right. Do you need any more time to speak with your attorney?
No.
No.
All right. One more time. You understand you have the right to go to trial, but by taking a plea today, you are giving up that right.
Yes.
All right. Mr. Shate, I'm not gonna take the plea today. He'll see his division judge tomorrow.
I'll see you tomorrow, Mr. Wright.
All right. James Acklin on page 13.
We tried, Judge, we tried.
Reach. Where's Mr. Acklin?
He's a manager. Come on up, sir. There's the judge, sir.
All right, Mr. Acklin, you're before the court on a KPS on a municipal ordinance violation, sir. The KPS was issued on the 3rd of this month. Do you want to resolve your case today, sir?
Yes.
All right, is it time served, is the offer? All right, Mr. Acklin, I'll sentence you to time served if you wish to resolve your case. Do you want to do that?
Yeah.
All right, please raise your right hand, sir. Do you swear or affirm to tell the truth?
Yeah.
Okay, you can put your hand down. And do you understand the offer that has been extended to you?
Yes, ma'am.
Is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
No, well, I'm a diabetic. That's all it is.
Okay, and do you need any more time to speak with your attorney?
No.
Sir, you understand that you have the right to go to trial, but by taking a plea today, you are giving up that right?
Yes, ma'am.
Have you ever been treated for mental or emotional illness?
No.
And do you understand, sir, that if you are not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
Yes, ma'am.
What plea do you wish to enter, Mr. Acklin? Guilty or no contest?
No contest.
All right, I accept your no contest plea. I find that it's freely and voluntarily given, and your sentence serves adjudication and time served. Good luck. All right, Mr. Shade, I couldn't find Miguel Rivera. Page 18.
It's also a felony matter, Judge, so I would just, if you do find it, I would just ask that it be sent to the division, because he's got a felony matter as well.
Oh, it was already sent to division, that's why. Okay,
Thank you.
yeah. All right, we can recall on page 9, David Meadows. Good morning, Mr. Franco.
Good morning, Judge. I'm glad you caught me. I was actually on my way over to the jail to see him.
Okay.
So now it helps me with that.
All right, so Mr. Meadows is before the court. Charge 1 is aggravated assault with a deadly weapon without intent to kill. Number 2 is aggravated battery causing bodily harm. And then 3 and 4 are no bond holds on violation of probation.
Sure.
And he has court tomorrow and on the 14th. 10, 11, and 10, Division FV tomorrow, and then Division FG on the 14th.
Your Honor.
FV, is that Judge,
If that should be ROR, Your Honor. His
Which
probation
one?
was terminated on count 4.
On
His
4?
probation was terminated on that case.
All right, so it looks like they're both before Judge All-Spector. So is it both of them that's been ROR, or is it two different
count-
cases?
The probation on charge 3 before Judge Allspector.
Yes.
is still,
It's still open.
Okay.
Count 4, it should have said Judge Weeks, but it's
Oh,
really a
okay.
moot issue since it's been terminated.
All right, so the VOP before Judge Weeks is been ROR.
that's right.
All right? So he has
Okay.
1 no bond hold at this time.
All right. Thank you,
Okay.
David. I'll be up to see you.
Your
All
Honor.
right, we need to just
Yeah.
set a bond on 1 and 2 then?
Your Honor, I'd be requesting a $2,500 bond on 1, $7,500 bond on 2, considering that he's on probation for felony battery before Judge Allspector. There's also, it was a felony matter that got pled down to misdemeanor battery, and as you can see, though it was terminated, he was on probation for unlawful possession of firearm. Would also be requesting, in addition to any bond the court sets, in order of no victim contact and no return to this establishment.
Judge, let me say this. There are a lot of extenuating circumstances regarding the counts that he was on probation for. They involved a dispute with an ex-girlfriend. She ultimately was charged with filing a false police report and actually she got arrested for making it up. We resolved the cases as they did because it was just easier for him. Can I ask for $2,500 on each? I can give you the long explanation. Maybe I should have brought the information against the ex-girlfriend in the old case. But I'm representing to the court that that's what it involved.
Under notwithstanding that, he pled out to a felony battery due to priors, which tells me he had a battery before that. While that case was outstanding, he picked up another violent offense that he pled out to a battery. And in this case, he attacked this victim for no reason, requiring the victim to receive 4 staples to close the laceration he received.
That I see.
All right, I impose a $2,500 bond on 1, a $5,000 bond on 2, and no victim contact.
And then he's got the no bond on the one.
Yes.
Okay.
All right?
Okay.
All right,
Thank
thank
you,
you.
Judge.
You're welcome. All right, Devin McGauley.
Please approach, Judge.
All right, Mr. McGauley is before the court on a trespassing charge, and I find probable cause.
Judge, it's being Mr. McGaul, you wish to resolve this matter today?
Offer be time served, Your Honor. No return.
All right,
He wishes to accept the state's offer, Judge.
all right, Mr. McGauley, please raise your right hand. Do you swear or affirm to tell the truth?
Yes.
Okay, sir, you can put your hand down. And Mr. McGauley, do you understand the offer that has been extended to you today?
Yes, ma'am.
Is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak with your attorney?
No, ma'am.
You understand that you have the right to go to trial, but by taking a plea today, you are giving up that right.
Yes, ma'am.
Have you ever been treated for mental or emotional illness?
No, ma'am.
And do you understand, sir, that if you are not a U.S. citizen, that by taking a plea today it could subject you to deportation or immigration changes?
Yes, ma'am.
What plea do you wish to enter at this time, guilty or no contest?
No contest.
All right, I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence, sir, is adjudication and time served, and also there's an order not to return to the 7-Eleven at 3800 North Andrews Avenue. Do you understand that?
Yes, ma'am.
All right. All right. Dante Culberson.
Mr. Culberson is here at main judge, approaching. Come on up, sir.
All right, Mr. Culberson, you're before the court on a 2017 KPS. It says you didn't show up for arraignment back June 14th of 2017, where the charge was operating without a valid license. All right, so I find probable cause.
Judge, my understanding, Mr. Culberson, I believe he self-surrendered. He wishes for me to ask the court if the court will consider resolving this matter today.
Offers to withhold court cost.
All right, it's a withholding court costs.
He wishes to accept the state's offer, Judge.
All right, Mr. Culberson, please raise your right hand, sir. Do you swear or affirm to tell the truth?
Yes, ma'am.
Okay, sir, you can put your hand down. And do you understand the offer that has been extended to you?
Yes, ma'am.
All right, is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak with your attorney?
No, ma'am.
You understand that you have the right to go to trial, but by taking a plea today, you are giving up that right.
Yes, ma'am.
Have you ever been treated for mental or emotional illness?
No.
And do you understand, sir, that if you are not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
Yes, ma'am.
What plea do you wish to enter at this time? Guilty or no contest?
No contest.
All right, I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence, sir, is a withhold adjudication and court costs. Good luck, sir. Sidman Griffin.
He's in North Broward, Your Honor. When I spoke with Mr. Griffin this morning, he indicated that he would like to try to resolve this case if possible.
North Broward.
All right, Mr. Griffin, you are before the court for a trespassing charge, and I find probable cause. Your attorney tells me you wish to resolve the case. Is that correct?
No, I wanted to plead no contest.
Right, well, that's resolving the case.
Oh, hell yeah.
Okay.
Offers withhold court cost, no return.
All right, so the offer to resolve your case is a withhold adjudication, court costs, and you cannot go back to this location. Do you understand that?
Yes, ma'am.
All right, so do you wish to accept that offer?
Yes, ma'am.
All right, please raise your right hand. Do you swear or affirm to tell the truth?
Yes, ma'am.
Okay, you can put your hand down, sir. And do you understand everything that we've discussed here today?
Yes, ma'am.
Is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak with your attorney?
No, ma'am.
You understand that you have the right to go to trial, but by taking a plea today, you are giving up that right.
Yes, ma'am.
Have you ever been treated for mental or emotional illness?
No, ma'am.
And do you understand, sir, that if you are not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
Yes, ma'am. I'm a citizen.
What plea do you wish to enter at this time? Guilty or no contest?
No contest.
I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence, withhold adjudication, court costs, and no return to that location. You understand that, sir?
Yes, ma'am.
All right. All right, Troy Mills.
Mr. Mills is also at North Broward, Judge.
Okay.
I did get a chance to speak with him this morning. He indicated that he would like to resolve this case if the court is so inclined. I can advise the court that in reviewing the clerk's computer system, Mr. Mills did not receive notice of his court date. Both notices that were sent were returned.
Well, is that because, what is the reason for that? Mr. Mills, there's an address of 5430 Flagler Street in Hollywood.
Yes, ma'am.
Do you still reside at that address?
Yes, I still reside there, but being that they found mold in the house around that time, they took me and my mama moved to my sister, but I kept going there looking to catch the mail, man.
All right, all right.
Yeah.
I just want to make sure that, you know, if anything else,
Still,
if anything else is going on, that you need to make sure that you check your mail. All right, State, you have an offer for Mr. Mills?
Be adjudication time served. I reviewed his driving record. This would be a second.
Judge, would the court consider, if he does enter the plea, dismissing the infraction that's associated with this case? It's an expired tag.
I didn't see that, but,
It's on the clerk's computer, Your Honor. It's not listed on the docket.
right. What is the traffic infraction for?
It says expired tag more than 6 months, Your Honor.
And that's part of this case number, 19-020788 TC 10A?
According to the clerk's computer, yes, ma'am.
It's fine, Judge.
All right, so, Mr. Mills, you'll be sentenced to time served. Do you wish to accept that?
Yes, ma'am.
All right, please raise your right hand. Do you swear or affirm to tell the truth?
Yes, ma'am.
All right, you can put your hand down. And do you understand everything that has been discussed here today?
Yes, ma'am.
Is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak with your attorney?
No, ma'am.
You understand that you have the right to go to trial, but by taking a plea today, you are giving up that right?
Yes, ma'am.
Have you ever been treated for mental or emotional illness?
No, ma'am.
And do you understand, sir, that if you are not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
Yes, ma'am.
What plea do you wish to enter at this time, guilty or no contest?
Well,
No contest is fine, sir.
okay, no contest. I was lost for, okay, no contest.
All right, I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence, sir, as to the suspended driver's license charge. And I also need to tell you that the state indicated that this is your second. Based on new law, if you get a third,
Yes, ma'am.
it's a mandatory 10 days in the jail. So just need to let you know that. All right?
Yes, ma'am.
Okay, so as to this charge, you're sentenced to adjudication and time served. And as to the traffic infraction that's attached to this case number, I will dismiss that charge, okay?
Thank you too, ma'am.
Okay. Tony Lawson,
Thank you, Your Honor.
Mr. Lawson is here present, Judge,
all right, Mr. Lawson, you are before the court. Charge 1 is petty theft. Number 2 is a misdemeanor capias. That capias was issued September 17th of this year, and the charge there is suspended driver's license. It says first offense. All right, I find probable cause.
Judge, it's me, Mr. Lawson. He wishes to resolve both matters today.
I just need to pull his driving record.
Okay.
It went from, when is it from? Gotta go through this whole, now we'll get through 10 days. While I'm checking on the theft, it would be a withhold court cost.
Theft charge would be a withholding court cost.
See any prior
Judge, in
DW?
count 1, he wishes to accept the state's offer, and we'll hear count 2 in a second.
I don't see any prior DWSs. The offer be a withhold court cost on that as well.
Okay.
Judge, he wishes to accept both the state's offers.
All right, and Mr. Lawson, you need to know, I know they're saying this is your first. You need to know that there's a new law that came into effect October 1st. And if you get a third driving while license suspended, depending on what's going on with you, it'll be a mandatory 10 days in the Broward County Jail, so you need to understand that.
Yes, ma'am.
All right, sir, so at this time, you will be sentenced to withhold adjudication and court costs. Do you wish to accept that?
Yes, ma'am.
All right, please raise your right hand. Do you swear or affirm to tell the truth?
Yes, ma'am.
Okay, you can put your hand down. And do you understand everything that we've discussed here today?
Yes, ma'am.
Is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak with your attorney?
No, ma'am.
You understand that you have the right to go to trial, but by taking a plea today, you are giving up that right.
Yes, ma'am.
Have you ever been treated for mental or emotional illness?
No, ma'am.
And do you understand, sir, that if you are not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
Yes, ma'am.
What plea do you wish to enter at this time, sir? Guilty or no contest?
No contest.
All right, I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence as to both charges are withhold adjudication and court costs. Good luck, sir.
And Your Honor, before we close the book on this, case 190-36370-TC40A also has an expired tag more than 6 months attached to it. Would the court consider dismissing the warrant in light of the plea? I'm sorry, dismissing the infraction
traffic
in light of the plea.
infraction, I'll do that.
Thank you, Judge.
All right.
Thank you, Mr. Miller. Thank you, Judge.
And Mr. Lawson, before you go too far, you have another case pending. And you need to see Judge Miller at I think she's at the South Courthouse, TC 40A.
Yes.
At the South Courthouse, that's on the 30th. So you need to be there by 2 p.m. on the 30th of this month.
On the 30th, okay. Yeah, that's what I was concerned about, because that was during the time when.
It's okay.
I didn't have a
This
job.
case is pending. You just need to go to court on this
All right,
case.
Marco McBurrows.
North Broward, Judge.
Judge, I had an opportunity to speak to Mr. McBurrows this morning. He is interested in resolving these cases if the court is so inclined.
Your Honor, I have no offer. I would ask the court not to take a plea. Mr. McBurrows has 3 cases right now pending before Judge Porth in mental health court, 1 on a felony and 2 misdemeanor thefts. This will also go to Judge Porth.
Judge, I was unaware of that, and so I would ask the court also not to accept a plea at this time.
All right, well, Mr. McBurrows, you're before the court on 1 charge of petty theft and another charge of resisting officer without violence. I find probable cause, and I see the pretrial is standing. Is that case in front of Judge Porth as well?
Yes, good morning, Your Honor. Nancy Matson, pretrial services, case number 190000533 CF10A for possession of juvenile. And, case number 1900966 petty theft prior conviction, requesting this pretrial is revoked on both cases, Your Honor. Yes, these cases are before Judge Porth. He placed them on pretrial August 27th of this year, Your Honor.
All right. Do we know how soon we could get him on Judge Port's docket?
Hey, excuse me.
Yes, sir.
Excuse me. I think I got a court date coming up. You know what I'm saying? Well, I'm gonna report to my court date. So if I can resolve this, I will get out. I'll make sure I report to my court date, October.
No, I can't resolve your case. You have 2 pending cases before in mental health court. So
I'm saying it's on the 17th, and it's pretty much the basis of the same charges, which I've been trying to resolve them cases too. So, you know what I'm saying? Once I go to his courtroom, I'm gonna try to get everything resolved. You know what I'm saying? So if I resolve this case, once I go to his courtroom, you know what I'm saying, I'm gonna try to get that resolved too. So basically, I'm telling you that I go to court on the 17th, so I'll be able to do that. You know what I'm saying? Based on my mom, she in the hospital right now. She on a machine right now.
all right, sir.
Can we go off the record for a moment, Judge?
Regarding this case?
Yes, regarding this defendant, Your Honor.
Okay. Burrows, I am going to revoke your bond at this time. You'll see Judge Porth. I am going to revoke your pretrial, I should say. And I am going to impose $1,000 bond on case number 19-000-966 MM20A.
So you saying I can burn out?
And on case number 19-00533 CF10A, I am going to impose a $5,000 bond. And you have and I'm gonna increase the bond on on the new arrests on $200 to $500. Okay?
So I can burn out.
All right. And then you'll go before Judge Porth on these charges, okay?
So I can burn out on.
Yes,
You saying
yes, you have bonds, sir. Shane Villarino.
how much would it be?
Shane Villarino.
Yes, he's here, President Judge.
Mr. Villarino is before the court on a touch or strike battery charge, and I find probable cause.
Judge, it's me, Mr. Villarino. Unfortunately, he's not going to be able to afford to post the monetary bond, standard bond of $1,000. Now, he's been here his whole entire life. He works at the labor pool, so as you know, whenever there's work, he gets anywhere from $60 to $80 a day. Now, he lives in Davie in a trailer. He's been living at the same location for about 10 years. He's charged about $100 a week living there, and he's been living there, like I said, for almost 10 years now. Judge, he will be coming back to court. He just can't afford to post his monetary bond. So we're asking for the court to consider releasing him on pretrial release.
Showing, one moment. 2013 out of Broward, resisting without violence. 2012 theft. He has gone to state prison. That was out of Lee and Collier counties. 2002 trafficking cocaine, burglary of a structure, sale delivery of cocaine, sentenced to 5-year state prison. Also, just noting the strength of the evidence in this case, this was witnessed. There was an independent witness to this incident.
Moment, please, Your Honor.
Mr. Romero?
Judge, as I said, he's going to come to court.
Oh,
but
I'm
he
sorry.
can't.
Okay, it wasn't you who spoke, it was Mr. Miller.
Judge, it appears that Mr. Villarino's last contact with law enforcement was more than 5 years ago, and so I'd ask the court to take that into consideration when deciding on Mr. Romero's request.
All right, I'll RR to pretrial supervision and no victim contact. Mr. Villarino, you need to report to the pretrial office no later than tomorrow morning. Failure to do so, a warrant will be issued for your arrest. Do you understand that, sir?
Yes, ma'am.
And also no victim contact, which means no phone calls, no text messages, no social media, no third-party contact. Do you understand that, sir?
Yes, ma'am. If she contacts me, I guess I call the police department. She contacts me.
You are to have no contact, so I don't know how she's contacting you, but you're to have no contact with her.
She was right there.
Jacoby Bonner,
Judge, I've been advised he bonded.
okay?
Mr. Lennon?
Danilo Lenin Trujillo.
He's approaching Judge here at me.
All right, sir, you are before the court on one charge of DUI, alcohol, or drugs. Number 2 is DUI with damage to property or person of another, and I find probable cause.
Judge, at this time, nothing to add. I'm gonna be contacting Mr. Lin and his friends to post his monetary bond.
All right.
Judge, I would add, if the court would consider ROR count one, just because it's duplicative of count two.
I'm gonna deny that. He has a $1,500 standard bond. Richard Braswell,
Oh, no, Mr. Brandwell?
Braswell?
Judge, in my docket says no paperwork, so I don't know if he's here or not here.
I have the paperwork, so I don't know why it says that.
And
Braswell?
more importantly, I have the paperwork, so.
Mr. Brandwell, if we could put it closer, then I can,
Honor,
so they can bring him?
Is Bondos posted?
Yes.
Oh, that's why, his bond has been posted. All right,
Okay.
thank you.
Bonded anyway. Beautiful. Okay.
Michael Seitz,
Mr. Seitz, come on up, please. He's approaching, Judge.
Mr. Seitz is before the court on a one trespassing unoccupied conveyance charge, and I find probable cause.
Judge, it's me, Mr. Seitz. He wishes to resolve this matter today.
All right.
One moment, Judge. Offers adjudication time served.
Adjudication time served is the offer.
He wishes to accept the state's offer, Judge.
All right, Mr. Seitz, please raise your right hand. Do you swear or affirm to tell the truth?
Yes.
Okay, sir, you can put your hand down. And do you understand the offer that has been extended to you?
Yes.
Is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
No.
Do you need any more time to speak with your attorney?
No.
You understand that you have the right to go to trial, but by taking a plea today, you are giving up that right?
Yes.
Have you ever been treated for mental or emotional illness?
No.
And do you understand, sir, that if you're not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
Yes.
What plea do you wish to enter at this time? Guilty or no contest?
No contest.
I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence, sir, adjudication, time served, and no return to this location. Do you understand that, sir?
Yes.
All right.
Good luck, sir.
Mason Maynard,
Mr. Maynard is here, approaching, Judge.
Mr. Maynard is before the court on one charge of robbery with a firearm. These are,
He's just here on count three, charge three, Your Honor.
okay, you're only here for the ad charge, which is carrying a concealed firearm. Is it correct only because this determination does have 1 and 2 that there's a no bond hold on the robbery with the firearm
I
charge?
believe confinement can confirm he already had a first appearance on the first two counts.
And $500 on 2? I just need to make sure because it's there, otherwise I'm just gonna cross it out, so. So, do you want me to cross out 1 and 2, or do you want me to, okay? All right, so I find probable cause, and he has a $1,000 bond on that charge, okay? All right, Malcolm Williams,
Mr. Williams, come on up, please. He's approaching, Judge.
all right, Mr. Williams is before the court on one charge of home invasion with a firearm or other deadly weapon, and I find probable cause.
The state would be seeking a no bond hold upon a finding of proof evident or presumption great for first appearance purposes only, relying upon the arrest warrant affidavit, additionally in order no victim contact.
Okay. All right, does the defense wish to be heard?
Yeah, Your Honor, we would just ask that the court not find proof as evidence or that presumption is great based solely on an affidavit to arrest. It seems that there should be more available to the court before making that determination.
All right, so, for the preliminary finding of proof evident presumption, great, I do make that finding this morning. That is without prejudice for Mr. Williams to have a bond hearing before his division judge. And until such time, he'll be held no bond on this charge.
Sorry, sir. Go that way.
And no victim contact, which means no phone calls, no text messages, no social media, no third-party contact. Do you understand that, sir?
Right now, she already made that decision as far as found proof evident presumption, great. But she's asking you to, if you understand her instructions.
I
No.
understand that.
Okay.
I understand the no contact. I'm asking you about the funeral Saturday. My daddy's funeral Saturday.
Judge, Mr. Williams wants me to ask the court, even though that you found proof evident and presumption great, he's asking if the court will consider exercising your discretion. My understanding is his father passed away and he would like to attend his father's funeral.
I think we need to have a more detailed hearing on that, so you may want to set a hearing before some emergency hearing at this time. All right, Trond Johnson.
Mr. Johnson, come on up, please. He's approaching, Judge.
Mr. Johnson is before the court on charge 1, possession of controlled substance without a prescription. And number 2 is a possession of drug paraphernalia. And I find probable cause.
Judge, Mr. Johnson is asking if the court would consider releasing him on pretrial release on this nonviolent offense.
All right.
Your Honor, I have no objection, would be requesting random testing.
So ROR to pretrial supervision, Mr. Johnson. Sir, you need to make sure that you report to the pretrial office no later than tomorrow morning. Failure to do so, a warrant will be issued for your arrest. Do you understand that, sir?
Yes, I do.
And also, you will be subjected to random drug testing. That's going to be part of your release. Do you understand that?
Yes, ma'am.
All right. Okay, Bernard Osias.
Mr. Osius is approaching, Judge. He's here. Maine, come on up, sir.
We're off the record again. Bernard Osias.
Yes, Judge.
All right, Mr. Osias is before the court for a robbery with a firearm charge. And I find probable cause.
The state would be seeking a no bond hold upon the finding of proof evident and presumption great for first appearance purposes, relying upon the arrest warrant affidavit from Detective Kidd of the Hollywood Police Department.
This one, oh, I know.
This is the one, Your Honor, where...
Oh, I see. This is the one, there's a rear ending.
Yeah, the victim's relative took a photo of the license tag from the vehicle where the two suspects fled from. The vehicle was traced back to Mr. Osias, and the victim identified him.
So based on the information that I have in the warrant, the affidavit to arrest, I am going to make a preliminary finding of proof evident presumption great without prejudice. Mr. Osias will be held no bond
Judge,
at
I'd
this
just like
time.
to register an objection.
Okay.
Based on this situation, it appears that the show-up was conducted, and I think we all know how suggestive they can be. Essentially, the only thing that was positively identified was a license tag. And so I would argue that proof, under these circumstances, with no testimony, with no actual evidence before the court, other than a hearsay affidavit, that proof, evident presumption grade, should not be found at this time.
Pedro Jimenez.
Mr. Jimenez, come on up, please.
Mr. Jimenez was before the court for a grand theft, and I find probable cause. Hear from the parties.
One moment. I don't know if Mr. Romero has anything.
Judge, I apologize. In speaking to Mr. Jimenez, he's not going to be able to afford $50,000, nor his family. Now, he was, I believe, brought here from Dade County. My understanding, Judge, he bonded, well, his family bonded and spent almost their whole financial resources bonding him out on the Dade County offense. Now, Mr. Jimenez is working. He works for a marble supplying company where he sells marble. He makes anywhere around $450 a week doing that. Now, he's been living in our community for 15 years. He's 32 years old. He lives in Homestead with his mother. His mother is on disability, and he's been living at that residence trying to help her out for the past 5 months. My understanding is she rents, does not own, and the rent is approximately $1,100 a month, so she's not in a position to post his bond. So he's still going to be relying on his brother-in-law, who helped him with his Dade County bond, but he works at a local country club as a server. So we're going to be asking, because there's no way he's going to be able to afford
How much bond was posted in Dade?
I believe it was a total of 15,000, so they came up with 10%, the 1,500, not all of it, and from what he says, they have an arrangement with the bondman to pay off the rest of that amount.
Okay.
So that's why we're gonna ask on this case, Judge, if the court would consider pretrial release. If not, we're asking the court to consider a bond reduction to about $3,500.
What's the charge in Dade?
I believe it's a theft-related offense.
It's more than a theft related. The reason that Judge Casey, I imagine, set the bond so high, and then he's got $15,000 in bonds in Dade, he's got, let's see, 5 open grand thefts in Dade County right now. As you can see, and it's mentioned, referred to in the affidavit, this is just ongoing, this is his MO between Dade and Broward County, these type of thefts, Your Honor. Additionally, he has a warrant out of Dade on a DWLS or fail to appear in court. There's a $3,500 bond on that. I don't know if he was picked up on that. It's still showing open in CCIS. He has a prior theft out of the state of Georgia. That's from 2008. And let's see. Possession of cocaine, 2015 out of Dade. All those other arrests are dropped. Your Honor, I'm not saying I'm opposed to the court modifying the bond. I just don't believe release to pretrial would be appropriate.
So he has 5 pending grand thefts in Dade.
Yes, ma'am.
What are those all this year?
Oh, yes.
They're all open, I believe, in the same, date, Judge.
All right, folks, a $20,000 bond is what I'm imposing at this time, okay?
What was that?
20,000. Tyrone Wilcher.
Sheila, does he still have a Dade County hold, this guy coming up? Wilcher?
Tyrone Wilcher, I believe, is at North Broward, Judge.
He was here, he spoke with the PD, and he decided to go back to the unit.
And Judge, I'm partially to blame for this. I did speak to Mr. Wilcher. He's got a court date tomorrow. He decided that he didn't need to be here, and for purposes of this hearing, I'm asking the court to allow me to waive his presence. I did not tell him to go back.
Well, because you said it's your fault. It's probably your fault. That's why I'm
Partially.
Partially.
Partially, because I told him nothing was going to happen today because he's got a court date tomorrow.
All right, so I'll find probable cause on Mr. Wilshire for petty theft, and he has a $750 bond, okay?
Thank you, Judge.
All right, Donald Pullen.
Please approach the judge. Swear me.
All right, Mr. Pullen is before the court. Charge 1 is robbery with a weapon. Number 2 is criminal mischief. Number 3 is resisting officer without violence. Number 4 is the same thing, resisting officer without violence. And I find probable cause.
Your Honor, the state is going to be requesting a $20,000 bond on count 1, pretrial release of the GPS monitor, no victim contact, no weapons, no firearms. In 2004, Mr. Pullen had an attempted kidnapping. He was convicted in 2005 and sentenced to 12 years in Florida State Prison. He was released in 2014. Nothing further from the state judge.
I apologize, Judge. I didn't hear what was the state's
$20,000 with a pretrial.
Thank you, Judge. And speaking of Mr. Pullen, he's not going to be able to afford that right now. He's looking for permanent work. What he does is he helps with moving jobs where he'll get paid anywhere from $250 to $350 a week, but he's looking for more stable employment. Now, he lives in Lauderdale with his cousin. He's been residing at the same apartment now for about 2 months. His cousin's mostly helping him out, but he gives his cousin about $100 a week to help him out with the expenses and things of that nature. Now, he does have priors, I believe, from what Mr. Lunder stated, but from what Mr. Pullen advised me, he's been clean for a number of years now. My understanding, Judge, unfortunately, he doesn't have his phone with him. He has no phone numbers memorized, so he has no one to help post his monetary bond. But Judge, if he were able to get in touch with anyone, it would be his girlfriend. And from what he advised me, his girlfriend works like in an office, so she's like an office staff worker, and we would be asking for about a $4,000 bond on his behalf, and also asking the court to sign a photo order so we can photograph the injuries that Mr. Pullen sustained.
All right, I'll sign that order. I have concern as to whether Mr. Pullen will come back to court. The officer responding to the silent alarm intercepted the defendant as he tried to leave the gas station property, which is where the alleged robbery occurred. I ordered the defendant to stop as I pulled next to him, but the defendant fled, running southbound through a park and then into Avis rental car. They had to set up a perimeter with a canine team. And while officers were arriving to the scene, it was revealed that the defendant had just committed an armed robbery of the business. Successfully taking cash from the register. Minutes later, the defendant was located hiding in a thick brush by the canine team. He was then positively identified and came in pretending to be a customer, then went around the counter into the employee-only area and placed a box cutter to the victim's torso and then to his neck to make him comply with his commands to open the register. All right. So based on those allegations,
Judge, one moment. I know the court says, you're, specifically as far as his, future appearance, my understanding, Mr. Pullen did advise me he has no failure to appear since past. So I'm asking you also to take that in consideration.
All right, so based on the allegations that I have before me, I am going to impose a $20,000 bond, and if he posts his bond, he'll be out on a level 2 pretrial supervision, okay? Andrew Mallory,
Mr. Mallory, come on up, please.
all right, Mr. Mallory is before the court on one charge of trespassing, unoccupied structure or conveyance. 2, 3, 4, and 5 are a violation of felony probation. Those are all no bond holds. And Mr. Mallory will see his division judge tomorrow at 8:30 a.m. I find probable cause. He has a $25 bond on one. I will leave that in place. Robbie Espino. Mr. Espino is before the court on one charge of license plates, counterfeit license plates. And number 2 is failure to register motor vehicle, and number 3 is an out-of-county felony hold. That's out of Miami-Dade, and that has a no bond hold, so you'll have to go to Miami to handle that matter. I find probable cause. I'm not sure why it says no, not for magistrate on number 1. All right. He has 1,000, yes.
I think that's an error as far as not for magistrate, but at this time, I'm not asking him if I'm gonna be contacting his mother to post his monetary bond.
All right, he has a $1,000 bond there. All right. Tawfiq Hammond.
Oh, Mr. Hammond, come on up, please.
All right, Mr. Hammond is before the court. Charge 1 is petty theft. Number 2 is violation of felony probation. Number 3, burglary. Number 4, grand theft. 5, 6, and 7 are violation of felony probation. And Mr. Hammond will see his division judge on those VOPs tomorrow at 8:30 a.m. All right, I find probable cause. And I'll leave the standard bonds in place. Okay?
Judge, nothing to request as far as the standard bond. You just want to know when was the alleged date of incident on counts 3 and 4?
It's in 2018, August 1st,
August 1st of 2018. Okay. Tron Clark.
Mr. Clark, I've been informed is a medical reset, Judge.
All right, Mr. Clark is a medical reset. Nathan McLeod.
Pardon, Judge. He's here.
All right, sir, you are before the court. Charge 1 is operating without a valid driver's license, and 2 and 3 are a violation of felony probation. Those, I don't know what state. Those are out of state, so it just says interstate on my paperwork. All right, so I find probable cause, and you will have a bond of $25 on 1. And 2 and 3 are out-of-state VOPs. Those have no bond holds. Brandon Paramore.
Mr. Paramore, I've been advised as a medical reset, Judge.
All right, medical reset on Mr. Paramore. John Harper.
Mr. Harper, come on up, please.
All right, Mr. Harper, you are before the court. Charge 1 is petty theft. Number 2 is false ID given to law enforcement. 3, through 9 are felony capuses with no bond holds and are not for magistrate. 10 and 11 are violation of felony probation. And those have no bond holds. Will go before Judge Porth on tomorrow at 8:30 a.m. I find probable cause. Okay? And I'll leave the standard bond in place on 1. Eduardo Rodriguez Frias.
He bonded, Judge?
Mr. Frias bonded. John Newsome.
He's approaching, Judge, here, man.
Your Honor, if I could be heard.
Yes.
Maybe till he gets up there.
He's here.
I just need to check one other thing.
That's Mr. Newsome. You're asking for him to be reset? Okay.
Well, Your Honor, I would ask that you advise, since he is standing there, I'd ask that you advise him at least of the charge, since he has to have his first appearance within 24 hours and he is present. I'm not saying that we can't reset it for PC determination and bond till tomorrow, but.
All right, Mr. Romero, your colleague has asked that we reset Mr. Newsome for tomorrow because he appears to be sleeping at the podium.
Yes, Judge.
He is before the court for a retail theft charge, and we can reset it for tomorrow, okay?
Okay, Judge.
All right, Benny Presendor.
He's approaching, Judge, here, man.
I ain't coming back tomorrow.
Okay. Mr. Presendor is before the court. Apparently, he wasn't sleeping. Charge 1 is driving while license suspended, habitual. Number 2 is improper turn, not for magistrate. I find probable cause.
Judge, we're gonna be asking if the court would consider releasing Mr. Presendor straight ROR or on the alternative on pretrial release. Now, my understanding, Judge, he doesn't live here, he actually lives in Gainesville. He got a call from his mom to help him repair her vehicle, so he got a bus and came over here to help his mom out. His bus ticket he was supposed to be going back today. Unfortunately, he's here, so he's gonna have to get that rescheduled. Now, he is working at Walmart. He's been there for about 1 year. He's been living here in Florida, I would say 27 of his 29 years. He's not a convicted felon, Judge. He will be coming back to court whenever he gets his court notice, but he can't right now afford to post his bond, nor his mother can afford. If the court's not inclined for a straight ROR, I'd be asking the court to consider releasing him on pretrial release on this nonviolent offense, even though he doesn't reside here in South Florida. He could still be supervised by pretrial living in Gainesville, so that's what I'm asking the court to consider.
Do you wish to respond? All right, so here's what we have. We have Mr. Presendor says that he's a habitual driving while license suspended, right? And, which means it's not the first time, and you've got to understand that if your license is suspended, doesn't matter what's going on, your license is suspended, and you know. So, I am going to deny the ROR. He has a $750 bond. I'm going to leave that in place. Willie Morris.
Judge, he is here and he declined the services of public defender, Judge.
All right, Mr. Morris, just so you understand that you are entitled to an attorney for this hearing,
Yes, ma'am.
and you are declining the services of the public defender's office at this time?
Yes, ma'am.
Okay? All right, so you are before the court, sir, for one charge. Charge one, burglary of a dwelling or structure or conveyance armed. Number two is grand theft of a firearm. Number three is grand theft. Number four, possession of weapon or ammo by a convicted U.S. felon. Number five is a felony capias. That has a no bond hold. That was placed by that division judge, and it's not for magistrate. Number six is a violation of probation. Number seven is a burglary, unoccupied conveyance unarmed. Number eight, violation of felony probation. Number nine, violation of felony probation. And then 10 and 11 are out-of-county felony holds. It says for Columbia County. And those have $50,000 bonds attached to them. Those are not for magistrate.
That was only at Columbia County?
Yes, sir. The two,
Say two holes.
Well,
there are two, well, it has $50,000 bond.
actually, on count six, charge 8 appears to be an interstate VOP. It looks like he's on probation for
Number
another state.
8. Right. Well, you have another, I don't know what state. It just says interstate. You have another no bond hold from out of state. Okay?
Your Honor, based on the state's going to be seeking a no bond hold upon a finding of proof evident or presumption grade on the armed burglary. Noting the allegations that Mr. Morris was, the entire incident was committed while under surveillance by law enforcement, and based on the statement from the alleged victim that there was a firearm in his car prior to this incident and that it was no longer there upon inspecting his vehicle after the alleged burglary was committed. Would ask the court not to exercise discretion, noting that he has no bond holds out of 2 counties and a separate state. He declined the PD.
All right, so Mr.
Yeah,
Yes,
he
he's
declined the
not
PD.
represented by the
He
PDs.
declined the PD.
Oh, never mind.
All right, so Mr. Morris, I am going to make a preliminary finding of proof evident presumption great. You are going to be held no bond on charge number 1.
And whatever the court believes appropriate on count 4, the state is fine with.
And then on charge number 4, I will impose a $5,000 bond. All right?
All right, ma'am.
I'm sorry?
Oh, and I didn't see that.
5,000 on 7. Thank you. All right. All right, Jeff Lee, Jean-Francois.
Judge, he's here. I asked him about 7 times, Judge. He's declining the services of public defender. Mr. Jean-Francois, come on up. Mr. Saunders.
All right, Mr. Jean-Francois, do you understand that you are entitled to counsel at this hearing?
Yes, Your Honor.
And are you refusing the services of the public defender's office at this time?
Yes, ma'am.
And you wish to proceed through this first appearance hearing representing yourself, is that correct?
Yes.
Okay. All right, so then you are before the court today. Charge 1 is burglary, unoccupied dwelling unarmed. Number 2 is grand theft. Number 3 is unlawful possession of personal ID of another, 5 or more. Number 4, resisting officer without violence. Number 5, burglary, unoccupied dwelling unarmed. Number 6, grand theft. Number 7, grand theft. Number 8, petty theft. Number 9, burglary, unoccupied conveyance unarmed. Number 10, grand theft. Number 11, grand theft auto. Number 12, causing cruel death, pain, and suffering to animal. Number 13, burglary, unoccupied conveyance unarmed. Number 14, grand theft. And number 16, larceny of credit card. Sir, I find probable cause for all these charges, and at this time, a pretrial is standing. I'll hear from pretrial first.
He's currently at case number CF 10A, grand theft auto, grand theft, possession of marijuana, 2 grams or less, and resist obstruct without violence. We're requesting his pretrial is revoked. He was placed on pretrial August 23rd, 2019.
And actually, Your Honor, and before I get to these charges, I'd ask that the court make that a no bond hold. He was placed back on pretrial August 23rd. He was already on pretrial before that. He was taken into custody by ICE. He was released. He didn't have his GPS monitor on. Pretrial, according to the warrant, pretrial contacted him, asked him to come in so they could put the GPS monitor back on him. He never showed up. Judge Kohler signed a warrant setting his charges at no bond, then put him back on August 23rd on the GPS monitor. And now we're here today.
All right. All right, so on case number 18-6548 CF10A, sir, you were on pretrial for grand theft auto, grand theft, possession of marijuana, resisting without violence, and the pretrial is asking again this morning that your pretrial be revoked. I will grant that request from pretrial, and you'll be held no bond on that case. Okay?
Your Honor, as far as these charges, I'm greatly concerned for the safety of the community and property of the community, considering while out on a GPS monitor for grand theft auto, it's alleged he broke into 2 separate homes. On those, I'm going to be asking for $25,000 each. And maybe even more concerning, he allegedly, he broke into a car that had the victim's handicapped dog in the back seat. He stole the vehicle. He discarded the vehicle, leaving this dog stranded to its own devices, locked in the car. When the car was later found, the dog was found, unfortunately, deceased. And what I can only imagine, greatly suffered. Your Honor, the evidence in that case, when he was apprehended, the key was found in his constructive possession of the vehicle, and his GPS monitor places him at the parking lot where the vehicle was stolen from at the time it was stolen. On the burglary conveyance, I'd be requesting a $7,500 bond on 9, $5,000 bond on 13. I understand a convenience bond was set on charge 12, but in light of the circumstances, I'd be requesting a $10,000 bond on that count. Should he be eligible for release on these charges at some point, I'd also ask for a GPS monitor.
All right, sir. Finding probable cause on charges 1, 5, and 9. You will have a $25,000 bond on those charges, and the other standard bonds will remain in place. As to charge number 12, which is the charge of causing cruel death, pain, and suffering to animal, that charge, you'll have a $10,000 bond. And as to charge number 13, also, you will have a $25,000 bond. And, sir, if you post your bond, you will be also be on a level 2 pretrial supervision.
So the other charges, you don't have PC for them now?
I find probable cause for everything, for all 15 charges. Just as the ones that I called out are the ones that did not have standard bonds attached to them. So in addition to the ones that you heard me call out, I can tell you on charge 1, you have a $25,000 bond. 2 and 3, you have a $1,000 bond. 4, you have a $100 bond. 5, you have a $25,000 bond. 6 and 7, you have a $1,000 bond. 8, you have a $100 bond. 9, you have a $25,000 bond. 10 and 11, you have a $1,000 bond. 12, you have a $10,000 bond. 13, $25,000 bond. 14, $1,000. and $15, $100. And in addition to that, you'll be on pretrial supervision. You understand that, sir?
Yes, ma'am.
Okay.
Good luck, sir.
All right, Cheyenne Adams.
Please approach the judge's chairman.
Mr. Adams is before the court on two charges, 1 and 2, a robbery with a firearm, and number 3 is displaying a firearm during a felony.
Your Honor, the state would be seeking a no bond hold on counts 1 and 2 upon a finding of proof evident or presumption great for first appearance purposes only. Not, in light of the charges on 1 and 2, I'm not asking that any bond be set on count 3. Your Honor, I'm relying upon the probable cause affidavit from Detective Jeffrey Payne of the Coral Springs Police Department, noting that Mr. Adams was identified by 3 separate individuals, 2 of which were the victim, the third being a witness to this incident as the person that committed the armed robbery. Your Honor, I would also ask, should the court find proof evident or presumption great that you not exercise discretion, Mr. Adams is currently on conditional release until the age of 21 on a case before Judge Siegel, where in 2017 he was convicted of aggravated fleeing and eluding causing serious injury or death, driving without a valid DL causing serious bodily injury or death, grand theft auto, resisting without violence, operating without a valid license.
All right, I find probable cause, and I'm making a further preliminary finding of proof evident presumption great without prejudice for Mr. Adams to have a bond hearing before his division judge. He will be held no bond until such time.
And Judge, the defense at this time would register an objection to finding a proof evident presumption great based solely on the hearsay probable cause affidavit that is before the court.
So noted.
And Your Honor, just ask for no victim contact on 1 and 2, please.
Sir, no victim contact on, at all, on both charges. ROR on 3, thank you. Jacob IU?
No. Just the, I didn't say anything. I said just.
Question, Judge.
All right, sir, you are before the court on a petty theft charge, which is a felony petty theft. It's a 3rd-degree felony. Number 2, you have an out-of-county felony hold for Palm Beach County. That is also on a grand theft charge. You have a bond there of $4,500. So I find probable cause, and you have a $1,000 bond on 1, okay?
Judge, speaking to Mr. Aru, he advised me, unfortunately, he has no one of contact because he knows no phone numbers, so nobody can help post his monetary bond here in Broward County.
Okay. All right, Howard Babbitts.
I believe no Broward, Judge.
Hello, Your Honor.
Hi, sir. You are before the court on a petty theft charge.
Yes,
And, I did find probable cause before, but we needed to reset, to discuss bond. So.
Okay. That's fine.
You have a $750 bond.
Judge,
Yes, ma'am.
I spoke with Mr.
Yes.
Babbitts this morning.
Yes.
I don't at this time have any mitigators to offer to the court. I advise Mr. Babbitts we're going to have to take this up with his division judge.
All right, so you have a $750 bond, sir.
That's very good.
All right, Brian Winter. Mr. Winter, you're before the court on 1 charge of aggravated assault with a deadly weapon without intent to kill. I find probable cause. We hear from the parties in regards to Mr. Winter.
Judge, I don't have the PC, and I did not speak to Mr. Winter.
Just need a moment, Judge.
I can look it
This
up
is an
online.
incident that occurred at Hard Rock Hotel and Casino. Defendant intentionally and lawfully threatened to do violence to the victim by brandishing a pocket knife while he was arguing with the victim. The defendant extended the blade of the knife, stepped towards the victim, which caused the victim to jump backwards because he was in fear of his life. At the time that this occurred, the defendant appeared to have the ability to carry out the threat. And that's basically it.
I have no objection if the court wishes to inquire as to Mr. Winter's ties to the community in lieu of resetting this.
Mr. Winter, are you able to post a bond?
No.
Are you employed?
My employee, no.
Where do you live?
Miami Gardens.
Who do you live with?
At a, recovery house.
Okay. How long have you been at this recovery house?
2 months or so, over 2 months.
Where were you living before that?
North Miami.
Okay.
Brookville.
Okay. Yes, state.
Your Honor, I'm showing he has an open, excuse me, criminal mischief in Dade County right now. He pled out a theft in Dade this year. Last year in Broward, uttering a forged instrument. Battery, 2011 in Dade.
All right, Mr. Winter, I'm gonna release it to pretrial supervision, sir. That means that by tomorrow morning, you have to report to the pretrial office to sign up. The deputy is going to give you the information for the pretrial office. If you don't show up, sir, a warrant will be issued for your arrest and you'll be back in this place. Do you understand that?
Yeah, okay.
Okay. All right, so, Deputy, can you please make sure that he gets that pretrial information?
Yes, ma'am.
All right.
And Your Honor, state would request no victim contact.
And also, Mr. Winter, I'm gonna tell you that you can have no victim contact. That means no phone calls, no text messages, no social media, no third-party contact. Do you understand that, sir?
Yes.
All right.
Your Honor, we'd also ask no return to the Hard Rock.
And you cannot go back to the Hard Rock Casino. You understand that?
Yes.
Okay. James Saunders. All right, Mr. Saunders is before the court on 3 petty theft charges. And I find probable cause. A corrective action was done. I don't have that anywhere. The booking reports, well. All right, the other 2 probable cause affidavits, September 15th and September 19th. All right, those do say grand theft. And then the one on, well, should it be 3 grand thefts?
No, it's 1 felony petty theft, 2 grand thefts.
Right, because it's, okay. All right, so number 1 is a felony petty theft, which is a 3rd-degree felony, and numbers 2 and 3 are grand theft charges. All right, I find probable cause. And
Nothing to add, Judge.
he has $750 on each. So I'm good, on each charge, I'm gonna leave that in place.
I think 2 and 3 are 1,000 each.
2 and 3. Well, that may be the standard bond, but I'm telling you that it says $750 here.
Your Honor, I'd ask that the court set them at 1,000, just so the court's aware. Mr. Saunders is out right now on a $1,000 bond for a grand theft that he was released October 2nd. And that's after he was arrested June 13th for felony theft, unlawful use of false ID affecting another, a VOP on a felony theft. He pled those charges out and was released August 10th.
Saunders, you have $1,000 on each charge, okay? Yes. Cyron Anderson,
Refuse?
Your Honor,
is this a second refusal? Or a third refusal?
might be a third. 'Cause he
It
was
might be a
supposed to be here
third.
on Tuesday, and then I guess, Sheila, do you show your notes? Did he refuse yesterday? Saron Anderson.
He has court before his division judge on the no bond holds that he has. This is I know that, I was on the bench yesterday, and so I know that on Tuesday he was on the docket. So, this is a third refusal, and so I'm gonna find probable cause in absentia at this time.
Is the court going to reset him for bond purposes or proceed on that?
No, I'm gonna proceed on setting a
Your-
bond.
Your Honor, the state is going to be requesting a $25,000 bond in GPS, considering that this was an alleged burglary where the victim was present in the residence at the time, and it also occurred while Mr. Anderson had a pending burglary of a dwelling. He removed his GPS monitor, and that was back in mid-December. The law enforcement, no one knew where he was since then.
Okay, so, $25,000 on one, and the other standard bonds are in place. He has 2 no bond holds, and he's set to see his division judge tomorrow at 8:30 a.m., okay? And then on Patrick Clavilo,
Hi, how are you, Judge?
I am well, sir. You are before the court on charge 1 is possession of cocaine, and number 2 is possession of drug paraphernalia, and I find
It was
probable
only-
cause.
Yes, it was only a little bit, but I was trying to,
Mr. Clavello, I'm sorry, this is Mr. Miller over at the court. I'm gonna ask you not to talk about what happened in your case today.
Why not?
Did you want to get drug treatment? Would you like me to ask this judge to
Yes,
put
I
you
would
in the
like drug
SAP
treatment.
program?
I would like drug treatment, yes, I would.
Okay, so Judge, we're requesting a SAP order for him at this time. We'll have to leave the bond as currently set. We can
All right.
address that later.
Okay. So, I'll sign the order to send him to the SEP program,
May I approach, Your Honor?
and he has a $1,000 bond, okay? All right, good luck, sir.
All right, thank you.
All right, everyone, I believe that's it for our morning docket, and I will see everyone this afternoon.